The following information, material, and content discussed and presented is covered under fair use. This is not intended to be, nor to be construed as, financial advice, tax advice, nor legal advice. If you need any applicable advice, please seek a licensed professional. To Be Fruitful Training Group assumes no liability for any actions you take using this information, as additional due diligence is required. All rights, titles, and actions or interests reserved ab initio without prejudice. Hey everyone, this is B with To Be Fruitful Training Group. All praises to the Most High. And today I wanted to cover something in a shorter video today. I just wanted to cover the Uniform Enforcement of Foreign Judgments Act in dealing with the domestication of judgments or the registration thereof. So we're going to look today at this particular article published by Muchmore & Associates PLLC. I'm not affiliated with them, nor am I advocating to go talk to them, but they do present this article, which is very telling. So I'll read this. So it says, introduction. This article will provide an overview of the law governing the recognition or domestication of a judgment rendered by a court outside of New York State. So generally speaking, this is dealing with a judgment or a decree issued in one court in one particular state and in use in either a federal court or another state, right? So it says a judgment rendered by a court outside of New York State is known as a foreign judgment and comes in two varieties, each governed by separate sections of New York's civil practice and rules. A judgment rendered by a court in the United States but outside of New York, i.e. a judgment from another state court, is known as a foreign judgment, but may also be referred to as an out-of-state judgment. And a money judgment rendered by a court in a country other than the United States is known as a foreign country judgment. In each instance, the individual who obtained the judgment must make an application to a New York State court for the recognition of a foreign judgment to enforce it in New York. A person or entity that holds a judgment is known as a judgment creditor. The individual or entity against whom the judgment has been entered is known as a judgment debtor. For the judgment creditor can begin the enforcement of foreign judgment, the judgment creditor must apply for the recognition or domestication of that judgment in the state of New York. The recognition of an out-of-state judgment is governed by Article 54 of the CPLR. The recognition of a foreign country's money judgment is governed by Article 53. In either circumstance, New York law provides for expedited proceedings for the recognition of the judgment. Recognition is not, however, automatic. In some instances, a foreign judgment creditor may raise defenses to the recognition of the judgment, and the court may refuse to recognize the judgment. The court may inquire into the sufficiency of due process provided in the foreign proceeding and other public policy concerns. It is therefore crucial for a judgment creditor to obtain expert legal advice prior to commencing an action to recognize a foreign judgment, and for a judgment debtor to understand their rights to oppose the recognition of or stay the enforcement of a foreign judgment. Full faith and credit for sister state judgments. Article 54 of the New York's Civil Practice Law and Rules, CPLR, enacts the United States constitutional doctrine of, quote, full faith and credit from Article 4, Section 1 of the Constitution. It codified the Federal Uniform Foreign Money Judgments Recognition Act, which requires state courts to respect the laws and judgments of courts from other states. The language of Article 54, Section 5401 of the CPLR provides the following definition for a foreign judgment. In this article, foreign judgment means any judgment, decree, or order of a court of the United States or of any other court which is entitled to full faith and credit in this state, except one obtained by default in appearance or by confession of judgment." End quote. The procedure set forth in Article 54 of the CPLR applies to out-of-state judgments not obtained by default or confession of judgment. In other words, the judgment must have been obtained after the defendant appeared in, defended, and lost the lawsuit. The procedure for recognizing out-of-state judgments. CPLR Section 5402 outlines the procedure for recognition of an out-of-state foreign judgment. First, a certified or authenticated copy of the foreign judgment must be obtained within 90 days after this. The judgment must be filed with the county clerk of the applicable county of New York State, together with an affidavit from the judgment creditor stating that the judgment was not obtained by default or confession of judgment, that it has not been paid or satisfied, the amount outstanding, that enforcement has not been stayed, and setting forth the last known address of the judgment debtor. Within 30 days of the filing of the certified or authenticated judgment and affidavit, a copy of the documents and notice of filing must be mailed to the judgment debtor, and proof of service must be filed with the clerk of court. If these requirements are satisfied, the out-of-state judgment will be treated in the same manner as a judgment from a court in the state of New York. Applying for stay of enforcement. Under CPRL Section 5404, the judgment debtor may apply for a stay of execution of the judgment on the grounds that 1. An appeal in the out-of-state jurisdiction is pending or will be taken, or 2. A stay of execution has been granted. In either case, the judgment creditor may commence judgment enforcement proceedings once the appeal is denied or the time to appeal expires, or once the stay of execution has been lifted. Finally, in certain circumstances, the judgment debtor may post a security or bond with the county clerk in New York to stay the enforcement of the recognized judgment. Article 53 of the New York's Civil Practice Law and Rules, CPLR, officially known as the Uniform Foreign Country Money Judgments Act, sets forth the conditions under which New York will recognize a money judgment obtained outside of the United States. Article 53 of the CPLR also applies to out-of-state foreign judgments obtained by default or confession of judgment. Section 5301 of the CPLR provides the following definitions. As used in this article, the following definitions shall be applicable. Foreign country. Foreign country means a government other than 1. The United States, 2. A state, district, commonwealth, territory, or insular possession of the United States, or 3. Any other government with regard to which the decision in the state as to whether to recognize a judgment of that government's courts is initially subject to determination under the full faith and credit clause of the United States Constitution. B. Foreign country judgment. Foreign country judgment means a judgment of a court of a foreign country. Importantly, under CPLR Section 5302, a foreign country judgment does not include a judgment for taxes, fines, or penalties, or a judgment related to divorce, spousal maintenance, or other judgment rendered in connection with domestic relations. A party seeking the recognition of a foreign country money judgment bears, quote, the burden of establishing that Article 53 applies to the foreign country judgment. The elements for recognizing foreign country judgments. The elements required for domestication of a foreign judgment include 1. The foreign court had both personal jurisdiction over the judgment debtor and subject matter jurisdiction over the case. 2. The foreign court was an impartial tribunal utilizing procedures compatible with the due process of law, and the enforcement of the foreign judgment would not be unfair, conducive to fraud, or violate New York public policy. Mandatory and discretionary grounds for non-recognition. New York courts may refuse to recognize a foreign judgment under certain circumstances, some of which are mandatory and some of which are discretionary, in other words, for a judge to decide in his or her discretion. Section 5304A of the CPLR sets forth the mandatory grounds for non-recognition. A court of this state may not recognize a foreign country judgment if 1. The judgment was rendered under a judicial system that does not provide impartial tribunals or procedures compatible with the requirements of due process of law. 2. The foreign court did not have personal jurisdiction over the defendant. Or 3. The foreign court did not have jurisdiction over the subject matter. The discretionary grounds for non-recognition include situations where the defendant did not receive sufficient notice to defend the action, the judgment was obtained by fraud, the action is repugnant to New York or United States public policy, the judgment conflicts with another final and conclusive judgment, the foreign proceeding was contrary to an agreement between the parties, the foreign court was a seriously inconvenient forum for the trial, the judgment was rendered in circumstances that raised substantial doubt about the integrity of the foreign court, the specific foreign court proceeding leading to the judgment was not compatible with due process of law, or a foreign country defamation judgment was obtained without satisfying the protection of freedom of speech and press as provided by both United States and New York constitutions. Stays of enforcement. As with Article 54 of the CPLR, a judgment debtor may be protected from enforcement where the foreign judgment is subject to appeal or stay of execution. CPLR 5306 section provides a stay of a proceeding pending appeal of foreign country judgment. If a party establishes that an appeal from a foreign country judgment is pending or will be taken, the court may stay any proceeding with regard to the foreign country judgment until the appeal is concluded, the time for the appeal expires, or the appellant has had sufficient time to prosecute the appeal and has failed to do so. Section 3213 CPLR, expedited procedure for an action to recognize a foreign country judgment. To apply for the recognition of a foreign money judgment under Article 53, the judgment creditor may utilize the expedited procedure provided for in Section 3213 of the CPLR, which governs motions for summary judgment in lieu of complaint. Summary judgment in lieu of complaint is discussed in greater detail in another article on our website, but briefly it can be used. When an action is based upon an instrument for the payment of money only or upon any judgment, and it is intended to provide a speedy and effective means of securing a judgment on claims presumptively meritorious, and where a formal complaint is superfluous and even the delay incident upon waiting for an answer and then moving for a summary judgment is needless. Where a foreign judgment creditor satisfies the requirement for recognition under Article 53 of the CPLR, a motion under CPLR Section 3213 can provide a cost-effective method of recognizing and enforcing the judgment without the need to engage in time-consuming and expensive discovery and litigation. Whether you are a judgment creditor seeking to recognize a foreign judgment or a judgment debtor seeking to oppose recognition or stay enforcement of a foreign judgment, consulting an experienced legal practitioner is key to understanding and making use of your rights. Important amendments to CPLR, Article 53 and the 2021 Recognition Act. In 2021, the then New York Governor Andrew Cuomo signed into law the Uniform Foreign Country Money Judgments Act, which amended the same Act of 1970, which first codified Article 53 of the CPLR. The 2021 law was intended to bring New York's legislation in line with the revisions proposed by the Uniform Law Commission in 2005. Key updates of the 2021 amendment were new mandatory grounds for non-recognition, and several discretionary grounds for non-recognition were also added. They made a differentiation between original and pending actions, and they narrowed the definition of foreign country judgment. And they also have a statute of limitations. So I will say, though, that while the Uniform Enforcement of Foreign Judgments Registration Act is essentially one of the ways that judgments are domesticated. Now, this act, to my knowledge, has been enacted in most states, and please be sure to check the procedures under the state statutes of the place that you're looking to enforce the judgment, because that is the one that's going to control. So, the one you're looking to enforce it in is going to have recognition under the statutes pursuant to that. Now, like I said, this is one of those things that can be done. It said here, certified copy or authenticated copy of the judgment. I will also make a note that an exemplified copy should theoretically work too. Again, this is not legal advice, it's not financial advice, nor is it tax advice. However, this is something that is a very big key that I think most people should probably learn and understand. So I hope this has been insightful. If you'd like to set up a one-on-one private call, please feel free to do so. I do have slots available. Also, if you need a trust, I do have the trust package available. I've reduced the price, just to reduce the standard price. It's not a sale price, it's just I've reduced that down to $600. So if you'd like to do it yourself and you just need the templates, I do have those available for $375, just because I don't have to spend as much time on that. And I do have other services available, so please check out my website. Please check out the Thursday calls. I have Thursday calls on Telegram in the exclusive equity live discussion Telegram group, where we go over different ways of administration and different remedies that can be done to properly administer the estate. Now, not everything is something that I can cover in the public, so I do have certain private remedies that I can't really even go over unless it's in a private setting, and that's what I have my Friday calls for. So I do have that available. Like I said, if you're curious, please check it out. Please like, comment, subscribe. It does help more than you know. Please share this with other people. Like I said, share this with anyone else that's in this space and looking to claim their minor accounts. Please, study this. Study the Domestication of Judgments. Study, authentication under the UCC. Study these different concepts. These are very key concepts that are required to be able to enforce certain types of interests. So, with that, all praises to the Most High. This is B with 2B Fruitful Training Group, and we'll see you on the next one. Thank y'all.